The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum Podcast, the podcast local governments need to do business. In the chair, it's me, Daniel J. Bolin. On the agenda today, we're at the 10th annual APA-CMS Bar Exam Planning Law Session, our annual law school simulation testing planners and land use professionals on the latest cases in planning law. This is our 10th year presenting the bar exam. We're glad to be back with Ansel Glink's Quorum Forum podcast at One Lake Brewery in Oak Park, Illinois. Every year we try to present a simulation of that law school experience, and naturally it takes place in a bar. And everyone that participates here today will literally pass the bar on their way out. But first, let's take the roll. We have a partner at Ansel Glink. His land use and zoning advice has helped municipalities, businesses, and entrepreneurs accomplish their economic development goals. He's a bar exam all-star, and we're going to ask him about it. Greg Jones is here. Greg, what are your top 10 bar exam memories? Go.
I don't know if I have 10, but I'm really enjoying shouting in a crowded bar right now.
That's one. Oh my gosh. Is this on? Now you're in real trouble. Well, you don't have to shout anymore, Greg, at least when you're holding this. But please keep shouting periodically throughout the course of the presentation.
I can handle that.
Next, we have a partner at Ansel Glink. She represents a variety of governmental bodies in the areas of municipal law, zoning and land use, economic development, and code compliance and enforcement litigation. She is also a bar exam all-star, and we're going to ask her about it. Megan Mack is here.
Woo! Are you asking me something?
Can I? We have to hand this back and forth. Megan, you won't believe it. I asked AI, artificial intelligence, about what the most memorable bar exam moments. Do you know what one of them was? At the time, here's a hint. At the time of this recording, dear listener, it is almost St. Patrick's Day, and this event sometimes falls around that time. And you all remember last year, Megan Mack showed us some of her Irish step dancing skills. Who wants to see that again? Put your hands together! Go, go, go! Megan, 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 Megan!
I promise you, after I've had 2 beers and we're done, I will do a little bit of a jig.
All right! Well, something to look forward to, dear listener, especially for our audio listeners who won't be able to see it. But we'll describe it to you in great detail. Behind the glass for our protection engineer Rick is present. We are also joined by our live audience of planners and land use professionals at One Lake Brewery. Let's hear it for you! We have a quorum. It's time for the APA-CMS Bar Exam. Rick, why don't you hand out the round 1 questions? There will be up to 4 rounds of questions, of 3 questions each. The people you're sitting with are on your team. If you chose to sit with them, and if they don't do well, that is your own fault. You decided to sit with them. We will hand out the question sheets. You also have answer sheets. Come up with a clever team name and put it on your answer sheets. And at the end of each round, we will collect them and go over the questions, answers, and the cases that they're based on. You will only have a few minutes to go over the questions with your team. It will not be enough time. You will say it's unfair. You will say we are mean. This only makes it more realistic, like the regular bar exam. Lean in and enjoy the experience. Any questions before we get started? Seeing none, let's go. Does everybody have a question sheet? Rick? Tell me when it's time. I'm gonna put 3 minutes on the clock. And let's go. 3 minutes. Go. Greg Jones. While everyone's answering the questions from round one, thinking about their planning law wisdom that they're about to learn, why don't you tell us some about what the APA Illinois chapter legislative committee is up to this year?
I'd be happy to, Dan. Thanks. So the legislative committee has been very busy now that the legislature's in session. There's a number of bills related to land use and zoning that are pending right now, including bills addressing missing middle housing, single-family zoning, parking near transit stops. There's a recent bill that was introduced to address Grants Pass, that Supreme Court decision that provided some guidance on regulations concerning homeless people and camping on public property. So we've got a full plate right now, and likely more to come. We've had a number of conversations with legislators who seem to be taking an increased interest in land use issues. So it's a busy time.
That is interesting to see these kinds of issues. It still is early in the legislative session, and so we're kind of see what there's 6,000 bills introduced every year. Only some of those make it out of committee. Only some of those make it out of one house. Only a fewer make it out of both houses, and even fewer of those are signed by the governor. It is a long journey, much like a basketball tournament. On the day of this recording, dear listener, we're going at the promptly when this session adjourns. The Illinois Fighting Illini are going to be playing Iowa in the Big Ten men's basketball tournament, and winning that many games in 4 days, it's really hard to do. Or 5 days? How many is it? 3, 5 days. So depends who you are. If you have a bye, double bye. To get to the tournament. It reminds me of the legislative process a lot. We're out of time. Everybody, lock in your answers and give them to Rick. If you don't give Rick your answers, you're not getting any points. He might seem like a really nice guy, but he can get mean if you don't give him your papers. Turn them in. Anyhow, Craig, I forgot to mention you're co-chair of this legislative committee. Who's your other co-chair?
The other co-chair is Drew Awesome, who is both awesome and has an awesome
This
last
is round
name.
one. I like him.
And Drew is a great partner in all the work that we do.
So, Rick was asking me a question. Make sure you answer all 3 questions. You're answering all the questions. I know, it's unfair, right? Get in there. Who didn't fill them out? Answer all 3 questions. We're going to give you a couple more seconds. Greg, if you were to power rank the co-chairs, how would you rank them from best to worst as a person?
I would definitely be the worst, hands down, no question.
Well, we're going through some. Do you guys? I know it's visited Springfield. You do that in some years, not in others. What are your thoughts for this year?
Yeah, I don't think we're going to make it down this year. We've done a legislative drive-down day in the past, but I think we're targeting 2026 to get back to it. But we're really focusing our efforts on trying to engage with legislators earlier in the session to see if we can influence legislation that way instead of a drive-down day later on. But it's always fun. It's always great to get down there. Look forward to getting back to Springfield.
I love getting down there. I love eating horseshoes. They've taken years off my life. Those are the sandwich with the Texas toast, your choice of protein. The toast is the shoe, the protein is the horse, the French fries on top of the nails, and the cheese on top are the guts.
Is it a sandwich if there's only one bun? There's no top.
This is a controversial statement. Send in your thoughts to podcast@answerblink.com. Is a horseshoe a sandwich? Use hashtag horseshoe in or out. to get through our email filter. We get too many emails. All right, does everybody have their questions in, Rick? Rick, you're being too nice. Rick didn't go to law school. He doesn't know what it's like. It's supposed to be really mean. But anyways, Greg, what's one of the bills that we should know about for the spring legislative session?
There's a bill that looks to eliminate parking minimums near transit stations. So transit stations being train stops, high volume bus lines, ferry terminals for those communities that actually have those. It was introduced last year in a different form. There have been some revisions that came back this year, but it appears to have some momentum. I would think that might be something that passes, or at a minimum, something to keep an eye on.
Something that's been of interest to me as an observer is it reminds me of the iterative legislative process. You talk about how something's introduced year after year, it comes back and back, and maybe it finally advances and maybe it doesn't. Is this regulation of Delta 8 THC products? I think a lot of communities are seeing these products show up on their gas stations and shelves and retail. These are products that are below the threshold to be considered cannabis, but have less than the quote-unquote legal amount of THC in them. They're currently unregulated. They were unleashed on the marketplace by the 2018 Farm Bill and the Industrial Hemp Act. And Rick says I should stop talking because it's time to go through round one. Thank you for round one. Let's go to round one, question one. Glinkford City adopted an ordinance that restricts group housing for individuals on mandatory supervised release. The ordinance prohibits more than one person on mandatory supervised release from living at the same address in residential zones, including separate units in the same building. An individual on mandatory supervised release challenges the ordinance under the Equal Protection Clause, arguing that it irrationally discriminates against him. Glinkford defends the ordinance by citing its interest in preserving residential neighborhoods for family use and preventing property value decline. Glinkford already has an ordinance in place that prohibits 3 unrelated persons from living in one household in family neighborhoods. The city files a motion to dismiss the lawsuit, arguing that the ordinance is rationally related to regulating governmental interests, including the preservation of residential neighborhoods and the preservation of property values. How should the court rule on the city's motion to dismiss? Is it A, the court should deny the city's motion because the governmental interest to pass rational review must be more than an irrational fear by a majority of voters? B, the court should grant the city's motion, finding that the ordinance was rationally related to legitimate government interests. Is it C, the court should grant the city's motion, holding that individuals on mandatory supervised release are not a protected class and thus have no viable claim? Or is it D, the court should deny the city's motion, ruling that strict scrutiny applies because the ordinance affects a fundamental right? Audience, what do we think it is? And for the answer, we go to Megan Mack.
Sounds like this audience did not get the correct answer. The answer is A.
Oh! Boom, roasted.
This case is Do Not Pass Go versus the City of Roxford. Corporate landlords challenged the city ordinance that restricted group housing available in the city for persons under state supervision on behalf of individuals who are on mandatory supervised release who seek to reside in the city under the Federal Equal Protection Clause. The plaintiffs are 2 companies that provide housing to individuals on supervised release in the city, in addition to the class of people who are on mandatory supervised release. The ordinance in question was amended in December of 2023 to prohibit more than one individual on mandatory supervised release and other forms of criminal supervision from living at the same address in single or two-family residential zones. This also includes multi-unit buildings, meaning they're not able to live in the same apartment complex in different units. Under the previous version of the ordinance, individuals on mandatory supervised release were only subject to a generally applicable rule that barred 3 unrelated people from living in one household in family neighborhoods. The city enacted this amendment in response to a perceived influx of sex offenders being placed in city from the Department of Corrections. On a motion to dismiss, the court applied a government-friendly rational basis review to the equal protection claim through the lens of plaintiff-friendly plausible claim for relief standard. In a zoning dispute specifically, it's especially difficult to overcome a rational basis test because courts are not willing to act as zoning boards of appeal. Thus, absent a fundamental right or a suspect class for a viable equal protection claim in the land use context, plaintiffs must demonstrate governmental action wholly impossible to relate to legitimate governmental objectives. However, a defendant subject to rational review cannot prevail at the motion to dismiss stage, and that's key to this case. We're at a motion to dismiss stage by offering any hypothetical justification for its policy whatsoever. Here the city offered 2 governmental interests: 1, to preserve residential neighborhoods for family use, and 2, to prevent the depression of property values for allowing housing for individuals on mandatory supervised release. The court notes that while both of these are legitimate on their face, it's not enough to overcome the hypothetical part of the motion to dismiss stage. As to the first interest, the court reasoned that the ordinance had already prohibited 3 unrelated people from living together in residential zones, so there's no coherent reason to distinguish between those unrelated that are not on mandatory supervised release and those unrelated individuals on mandatory supervised release. The court found the second interest to be a little bit more compelling, but it still found it to be invalid. While a presumption of rationality applies to the defendant's policy at the motion to dismiss stage, plaintiffs can overcome this presumption if their well-pleaded facts, taken as true, suggest the facts on which the legislature may have relied in shaping the classification could not reasonably be conceived to be true by the governmental decision maker. For a governmental interest to pass rational review, it must be more than the mere irrational fear by a majority of voters. At the motion to dismiss stage, the city has not shown any empirical evidence to justify its assertion that property values would diminish by allowing individuals on mandatory supervised release to reside together. So the issue couldn't be resolved at the motion to the dismiss stage, and the city's motion was denied. The court suggested in its opinion that parties continue to negotiate towards a mutually amicable resolution that balanced the city's needs with those of the plaintiff and the state.
Megan Mack, everybody. Question 2. A group of homeowners oppose Anceliot County's zoning board's approval of a variance for a wind farm project, arguing that the approval process violated their procedural due process rights because they were not allowed to call additional expert witnesses at the hearing. The zoning board, however, provided them with timely notice, opportunities to cross-examine witnesses, and the ability to present their own evidence. If the homeowners appeal the zoning approval, are they likely to succeed on their due process claim? Is the answer A, yes, because due process requires that all requested expert witnesses be heard at a zoning hearing? B, no, because procedural due process at a zoning hearing is flexible and does not require all the protections of a court trial? C, yes, because denying the opportunity to call an additional expert witness automatically results in a due process violation? Or D, no, because administrative decisions are not subject to judicial review? Audience, what do we think the answer is? I heard a lot of them. Greg.
Sounds like it was B. It is B. No. Nice job.
Go.
Procedural due process in a zoning hearing is flexible and does not require all the protections of a court trial. So this case is out of Knox County. It's Erickson versus Knox County Wind Farm. And objector county residents sued a wind farm company in the county to review a conditional use permit and height variation that was approved by the zoning board and the county board. and also sought declaratory judgment and injunctive relief. The wind farm company received approval to construct and operate a wind energy farm with turbines that were over 500-foot height limit under the county's ordinance. The project involved 60 wind turbines, so it was a big project, ranging from 550 to 600 feet in height. The taller, newer wind turbines were more technologically advanced and efficient than the older, shorter ones. And the applicant estimated that the project would provide the county with about $170 million in capital investment, new jobs, road improvements, and tax revenue. During the hearing, the wind farm called various witnesses to testify to the benefits of the project and its compliance with local, state, and federal regulations. Objectors called a few witnesses to testify that the project would not be prejudiced by the 500-foot limit, and also discussed noise standards and other hardships that the county residents thought they would endure if the project was approved. The hearing was continued twice, so it occurred over the course of 3 nights, but the hearing officer on the final night of the hearing denied the plaintiff's request to call additional expert witnesses. The objectors objected to this, stating that they wanted to call additional experts to talk about sound, health, and welfare and property value impacts. The trial court dismissed the claim with prejudice and found that the residents had timely notice of the hearing and a meaningful opportunity to cross-examine witnesses and be heard, and the appellate court affirmed that decision. On appeal, the residents argued that the trial court made a mistake by dismissing their claim. The trial court responded with stating that due process is flexible and calls for only such procedural protections as the particular situation demands. In the context of the zoning hearing, it is well recognized that not all the accepted requirements of due process that are found in a trial are necessary. So the court found that plaintiffs had meaningful notice and an opportunity to be heard. They extensively cross-examined the developer's witnesses, presented their own evidence, and called their own witnesses as well. They also did not show that the witnesses that the objectors wanted to call would have been an integral part of the decision, in that they would not have brought additional information to the ZBA's attention that they were not already aware of. So, in this case, the county and the developer prevailed, and the project was allowed to move forward.
Greg Jones, everybody. Let's hear it for him. Round 1, question 3. Rick Perez is starting to pass out answer sheets and question sheets for round 2, but you still have to pay attention to me if you want to learn something. Round 1, question 3. Inmate number 1225 is involved in a lawsuit with Christmas Village. The inmate sent a letter to Mayor Claus complaining about the conduct of Grinch, the city's attorney. The city denies the inmate's FOIA request for a copy of his own letter, and the inmate sues. Why should the city prevail? Is it A, the complaint about the city attorney's conduct does not pertain to public business? Is it B, the mayor is not a public body for purposes of FOIA? Is it C, a request for a copy of the requester's own letter does not further the purposes of FOIA? Or is it D, all of the above? Live audience, what do we think it is? I heard a lot of answers, but the correct answer is D. In Shahada versus the city of Taylorville, which bills itself as the Christmas capital of Illinois, the county seat of Christian County. They love Christmas there, hence this Christmas-themed question. And in that case, an inmate submitted a request to a city for a copy of his own letter he had sent to the mayor, complaining about the conduct of the city's attorney. The city denied the request, arguing, among other reasons, that the letter was not a public record under FOIA because it was addressed to the mayor, who did not qualify as a public body under FOIA. The requester sued the city, claiming the city's denial violated FOIA, and the circuit court ruled in the city's favor. The requester appealed, and the appellate court upheld the circuit court's ruling. First, the appellate court held that the requester's letter complaining about the conduct of the city's attorney was not a public record because it did not pertain to the transaction of public business, like business or community of interest, and instead pertained to the requester's private affairs, his own lawsuit against the city. Second, the appellate court ruled that the requester's letter addressed to the mayor did not qualify as a public record under FOIA because it was not received by, in the possession of, or under the control of a public body. After analyzing FOIA's definition of a public body and prior Illinois cases concluding that an individual alderperson was not a public body under FOIA, the appellate court concluded that the mayor is not a public body under FOIA. The court rejected the requester's argument that an individual alderperson should be distinguished from the mayor, noting that even a mayor, unlike an individual alderperson, has legal authority to make certain unilateral decisions and actions. That distinction does not transform the mayor into a public body under FOIA, according to the court. Finally, the appellate court determined that the requester's request asking for a copy of his own letter was inconsistent with FOIA's legislative purpose of making public records open and accessible to the public, because requiring the city to provide the requester with a copy of his own letter would do nothing to further that purpose. I was surprised by the result of this case, because I thought the city attorney's conduct does pertain to public business. At least that's how I behave when I'm doing city attorney business. And then there's a first district case that says the mayor's office is a public body, and they didn't even talk about that case in this case, which drove me nuts. See, he can't believe it. He can't believe it. I can't believe it either. But if we're looking for a silver lining, this is a good decision for municipalities and units of local government. A result maybe showing a split in the appellate courts. Rick, I need a score update. Who's first, second place? First place, we got SR Collaborative, followed by Team 4 for 4, which only went 2 for 3, and the Red Beards. And the rest of you are following up. All right, we're going to take 3 minutes, and you guys are going to answer the questions around 2. Let's go. Meanwhile, I'm going to talk to Megan Mack from Ansel Gibbs Law Firm. How are you doing, Megan?
I am fabulous, Dan. How are you?
I'll hold the mic. We have one for the listener. We have one microphone, and we're doing our best. So, 10 years, the APA-CMS Bar Exam. I'm very grateful for the APA-CMS having us back every year, notwithstanding a strong tradition of technical difficulties, cruel questions, impossible to overcome, trivia. But what are some of your favorite moments? What are your favorite reasons to do the bar exam every year?
I want to say it's spending time with you, Dan. And getting to enjoy your podcast voice right next door to me, and not over the wires.
Yes, to the extent that folks can hear the podcast voice in this brewery. We do have a very nice audio, and they are being very accommodating to us. I'm grateful for them hosting us this year. This is an outstanding location. The one of the organizers was mentioning, I think this is a adapted use project. This brewery, check it out, dear listener. The One Lake Brewery in Oak Lawn, Illinois. Oak Park, Jesus. Oak Park, Illinois. And so we're very excited to be back. Excited they'll have us back. What are some of the more interesting issues that you're working on with local governments these days?
Well, I think we were talking earlier about Grants Pass, and obviously we've got a watchful eye on what Springfield's going to do with that legislation. I was talking to some police officers about some pending legislation earlier today, or I'm sorry, I believe it was yesterday. There's some really interesting proposed changes to criminal law that will affect some of our clients as well. I don't know if you are familiar with some of the proposed changes that the legislature is discussing with respect to search warrants.
Oh.
There's some bills kicking around that would require police officers to wait 30 seconds before executing a search warrant. Kind of
Yeah.
That 30 seconds a lot can be done in 30 seconds. Another interesting bill that's out there is one that's proposing search warrants to be executed between certain hours of the day, so as to not mess with criminal sleep, I guess. Not a fan of that one either.
We're out of time. Let's go. Rick, pick up those sheets. You're being too nice to these people. Rip it out of their hands. Violently.
That's a Rick's process.
So yes, those are interesting bills, interesting legislation. The Grants Pass case you mentioned, of course, was the Supreme Court decision last year that upheld a no camping ordinance or ordinances under the 8th Amendment. It wasn't cruel and unusual punishment, but the Supreme Court did say there might be state laws in your state. Your mileage may vary in terms of how you are able to enforce those laws. We have the Bill of Rights for the Homeless Act in Illinois. There are proposals to amend that very bill to address these issues, and we're looking forward to Rick finishing collecting all the sheets. Are we ready? All right, round 2, question 1. Let me hear you. A developer sued Glink Village, claiming that Glink's use of eminent domain and other land use decisions violated his equal protection rights under the 14th Amendment. The village had taken land for road construction and later returned it, but the developer argued that the village's decisions were discriminatory and motivated by personal animus against him. What must the developer prove to successfully claim a violation of equal protection based on a class of 1 argument? Is it A, that the village's decisions were made arbitrarily without any justification? Is it B, that he was treated differently from others similarly situated and that there was no reasonably conceivable rational basis for that difference in treatment and the difference in treatment was intentional? Is it C, that the village acted with malice and intent to harm him specifically? Or is it D, that all of the village's decisions were incorrect or unfavorable to him? Live audience, what do we think the answer is? And for the answer, it's Megan Mack.
I think the length of this answer gave it away, right? The correct answer is B. This case is Greenwood Family. I have to read this because it's convoluted. Greenwood Family Limited Partnership versus Mukwonago. Mukwonago is a village. It's out southeast, 30 minutes southeast outside of Milwaukee. The developer challenged the village's use of eminent domain to take land from the developer's 5-acre parcel for road construction. The village actually returned the land, but the developer filed an amended complaint, including a class of 1 equal protection claim under the 14th Amendment that pointed to 6 adverse municipal decisions regarding its properties, but mainly focusing on 2 decisions. The developer's family had actually had a really good run of development in this community for about 13 years. When some of the city staff changed over, they then filed suit believing that they had an equal protection claim. The first claim involved the developer's proposal to buy a plot of land, leaving the sellers with a remnant parcel. The sale was contingent on municipal approval to the land division, which required a certified map, and the developer planned and outlined the construction of an access road so that the sellers would not lose access to the remnant parcel. Because the developer did not provide this information, the request was denied and the sale was canceled. The village did later end up buying that same parcel of land and developed it itself. The second decision involved a road that the village planned to construct across one of the developer's parcels. The developer opposed the taking, and the village began the eminent domain process. After the developer sued the village, alleging that the taking did not serve the public, it was intended to harm the developer, the village returned the land, acknowledging that it would help the developer in an ongoing transaction for the parcel. After the land was returned, the developer amended its complaint to include a violation of its right to equal protection, and the village removed the case to federal court.
You might get 3.
The district court granted the village's motion for summary judgment, finding it a rational basis for each of its land use decisions that the developer complained of. To succeed, the developer would have needed to show that it was treated differently from others similarly situated, and there was no reasonable, conceivable, rational basis for the difference in treatment. The court found the village made each land use and public funding decision based on taxpayer costs, commercial benefits, land use planning objectives, and other community needs. In other words, the village acted rationally and was guided by the factors a municipal land use and development body would be expected to consider. Although the developer cited communications from the village administrator which seemed to show personal animus towards the developer, the court found that his communication didn't matter since the village had ample justification for each of its decisions. While the partnership is a disappointed landowner, it is not the victim of unconstitutional discrimination.
Megan Mack, everybody. Question 2. Round 2. A religious organization challenges a Glink Village zoning ordinance, arguing that it discriminates against religious assemblies by requiring them to apply for a special use permit, while some secular organizations would not have to apply for a special permit. However, the church never applied for a special use permit and never bought property in the village. Is the church likely to succeed on its challenge? Is the answer A? Yes, because the zoning ordinances that do not explicitly permit churches in any district are per se unconstitutional. Is it the answer B? No, because the church never applied for a special use permit, so it cannot demonstrate that it was treated unfairly compared to secular organizations. Or is the answer C? Yes, because the church wasn't able to purchase real estate in Glink Village. Audience, what do we think the answer is? And for the answer, it's Greg Jones.
It's B. Great job, everyone. So this is a case that involved the village of Hazel Crest. The church sued the village, alleging that the zoning ordinance discriminated against religious assemblies in violation of the Equal Protection Clause, the Constitution, and the Religious Land Use and Institutionalized Persons Act, commonly known as RELUPA, and was unconstitutionally vague. In its search for a permanent location, the church identified the village as a possible home, but it wasn't able to find a property that was large enough to hold its growing congregation. The church claimed, however, that their trouble in finding a location was a result of the village's discriminatory zoning ordinance. The ordinance in question established 9 separate zoning districts, 4 for residential, 2 for business, 1 for limited manufacturing, and 1 planned development district, none of which allowed churches as a permitted use. This meant that the church would have to apply for a special use permit, which is a multi-step public process that can be a pain in the butt. In addition to claiming the ordinance is unconstitutionally vague, the church argued that by not including churches as a permitted use in any of the village's 9 zoning districts, the village denied it the ability to meet freely as of right. And the village was forcing religious groups to go through an onerous and expensive, time-consuming, and overly discretionary, these are direct quotes, process to obtain a special use permit. The village imposed burdens on religious assemblies that were not imposed on other non-religious groups, the church argued, which violated the Equal Protection Clause of the 14th Amendment and RELUPA. The district court disagreed and granted the village's motion for summary judgment, finding that RELUPA did not apply because the church never had a property interest in any real estate located in the village. In addition, the ordinance did not violate the Equal Protection Clause because the church never sought a special use permit, which precluded the possibility of discrimination against the church. The church did not show that they were treated worse than comparable secular organizations, and there was no property in the village that could accommodate the church's needs. The court also rejected the vagueness challenge, noting that other zoning codes included comparable language. The moral of the story here is you do not get what you don't ask for. If an applicant does not file an application, you can't sue and claim that you were wrongfully denied.
Greg Jones, everybody. Let's hear it for him. Rick Perez is passing out round 3 question sheets and answer sheets. It is loud in here, so for question time, If you have questions about any of the cases or compliments for the hosts of the podcast, please write those on your answer sheet as well, and we'll try to receive them and answer them that way. Let's do that, or give that a try. But first, it's round 2, question 3. The city of Glinkford and the Bolin Foundation want to build a museum to honor Mayor Dan Bolin and to provide the community with educational programming initiatives. However, a historic preservation group opposes the construction of the Dan Bolin Center in a historic park. The preservation group sues to stop the construction of the center and under the public trust doctrine, which requires certain park land be held for the public's benefit. How should the court rule? Is the answer A? The court should stop the Dan Bolin Center because it will not benefit the public. Is it B? The court should stop the Dan Bolin Center because it will destroy the historic park and it is in the public's best interest for the park to remain untouched. Is the answer C? The court should allow construction of the Dan Bolin Center because it will provide the public with valuable educational and aesthetic benefits? Or is the answer D? The court should allow construction of the Dan Bolin Center because the park was previously submerged in navigable waters. Live audience, what do you think the answer is? C, that's right. You love the Dan Bolin Center. It should be built. Am I right? Build it. Build it. The answer is C. This case is the most recent in a long line of challenges from Protect Our Parks, or POP, against the construction of the Obama Presidential Center in Jackson Park. POP's most recent effort raised several arguments under both state and federal law to prevent the construction, including claims under the public trust doctrine and challenges to the federal agency reviews associated with the project. For its public trust doctrine claim, POP argued that Jackson Park is held in public trust under Illinois law, meaning that the city of Chicago acts like a trustee with fiduciary duties. They claimed the city violated these duties by transferring park land to the Obama Foundation and giving them control over it. The public trust doctrine prevents the state from handing over public lands, especially those under navigable waterways, to private parties for private use. It has expanded to include certain parks and conservation areas. Illinois courts use a 3-part test to determine if there is a public trust violation. The property must be held by a government body for public use. The government body must have taken action allowing the property to be used for something inconsistent with its original public use. And the action must be arbitrary or unreasonable. POP argued that the city's actions violated the public trust because the land was being used for a private purpose. The court, however, disagreed. The Illinois General Assembly amended the Museum Act to specifically allow cities and park districts to build museums, including presidential centers and public parks. This law also allows them to contract with private entities for construction, maintenance, and operation. The court found that the center fit within this legislative authorization. Therefore, the court determined that the center would serve a public purpose by preserving presidential records, offering educational programs, and expanding cultural resources. The court acknowledged that the foundation would benefit from operating the center, but stated that under Illinois law, this alone does not violate the public trust doctrine, so long as the main purpose benefits the public. POP wanted the court to apply stricter scrutiny because of alleged flaws in the agreements between the city and the foundation, arguing that the public trust doctrine incorporates fiduciary duties from private trust law. The court rejected this, stating that POP had not shown that Illinois law recognizes this theory. POP also argued that the General Assembly could not change the original purpose of Jackson Park. The court cited the Soldier Field case, noting the court's limited role to ensure that there has been a sufficient manifestation of legislative intent to promote the diversion and reallocation contemplated by the plan. POP also challenged various federal agency reviews, arguing that, among other things, that the National Park Service and U.S. Department of Transportation should have done a full environmental impact statement. The court determined that the agencies took the required hard look at environmental consequences, including analyses of the impacts on trees and migratory birds. POP argued that judicial deference to administrative agencies is no longer favored, citing recent Supreme Court cases establishing that major questions of economic and political significance should be decided by Congress. The court found that Pop did not argue this case raised a major question, or that the so-called major questions doctrine changes the review of administrative procedures. So the court rejected Pop's other arguments and affirmed the lower court's decision, allowing the construction to continue. That's it for round 2. Where are we? Looking at the scoreboard, first place is still SR Collective, followed by a tie for second place, Team 4 for 4, and the Redbeards. This is your last chance. We're going to blaze through round 3. You have your question sheets, your answer sheets. Let's go! We're going to do 2 minutes for this one, because we're mean. And the game tips off soon. Greg, we've been through a lot together. Megan, we've been through a lot together with Bar Exam over the years. Remember, this started 10 years ago at Jack's Tap in the West Loop. R.I.P.
Rest in peace.
I think we destroyed it, and that's why it's no longer operating.
It's a Mardi Gras theme.
Where did we go after that?
Oh yeah, we did Planning Law Mardi Gras one year for the Bar Exam. That was fun.
What was the place in the south? What was the place that we used to go to that was west side? Begins with an H.
Haymarket Brewing was our home for a long time. We went to Vintage Bar last year, and this year we're even further west in the West Loop. Very West Loop. In Oak Park.
Was there a remote COVID?
Yeah, we did a couple remote bar exams through the pandemic. Remember, at the time of this recording, 5 years ago, this week, Tom Hanks was just really bumming us out. And then after that, a few things happened, and then we were here today. But we survived, we're thriving, and in about 30 seconds, Rick's going to start picking up your papers, so get your answers in, because round 3 is going to be a lightning round. I can't emphasize enough how much I want to watch this basketball game. I want to be respectful of your time, and thank you all for having us back. This is sincerely one of our favorite events, if not our favorite event every year. This is so fun to do. The timer's going off. Rick, get him. Can you imagine what will the bar exam be like in 10 years from now, Greg?
Even younger and better looking, I think, because we're like Benjamin Button reverse aging up here, right?
You know what I was thinking? What if we were to combine the bar exam with a Pedway crawl?
The Pedway in downtown Chicago, of course, is a linked series of subterranean tunnels, a great place to get lost.
COVID friendly.
The pandemic's still happening deep in the tunnels of the Pedway. That's it. You got them all, Rick? All right. Round 3, question 1. A casino owner filed for injunctive and declaratory relief against the state of Ancellia Gaming Board and the city of Glingford after not receiving a license when the city sent other applications to the gaming board for approval. The circuit court dismissed the casino owner's case for lack of standing, and while the appellate court reversed this decision, the Ancellia Supreme Court ultimately affirmed the circuit court's ruling. What was the primary reason for the Ancellia Supreme Court determined that the casino owner did not have standing to challenge the board actions? Was the answer A, the casino owner's application did not meet the necessary qualifications in the Ancellia Gambling Act? B, the city had discretion in choosing which applications to certify, and the casino owner had no vested right to a specific application process? Is the answer C, the gaming board acted improperly in issuing licenses without proper oversight from the city? Or is the answer D, the casino owner failed to submit his application in a timely manner according to the state's regulations? For the answer, it's Mega Mac.
The answer is B. This is the Waukegan Potawatomi Casino versus Illinois Gaming Board case. Following the General Assembly's amendment to the Illinois Gambling Act to authorize the Gaming Board to issue 6 new casino licenses, the plaintiff casino submitted a proposal along with several other entities. The city of Waukegan, which the proposal was submitted to, approved 3 applications, but not the plaintiffs. The casino then filed for injunctive and declaratory relief 2 years after the certification process ended, seeking to prohibit the gaming board from issuing new licenses to the city's alleged non-compliance with the relevant statute. The circuit court granted the board's motion to dismiss with prejudice for lack of standing. The appellate court reversed the dismissal and remanded. The Illinois Supreme Court took the case up and reversed the appellate court, affirmed the circuit court's finding that the casino did not have standing to bring its injunctive and declaratory relief action. Under the amended gambling statute, the gaming board, who would ultimately choose to issue a casino license, could only do so after the city certified to the board certain prerequisites. Once the prerequisites were certified to the board, the city's involvement with the proposal ended. The plaintiff contends that the owner's license awarded another entity was void because the board did not have agency jurisdiction over the application, alleging that the board proceeded on applications improperly certified by the city. However, the application certified to the board from the city appeared on their face to comply with the statute, so the board did have jurisdiction to consider the applications and the owner's license was valid. Further, because the owner's license was valid and the board complied with all statutory requirements, the court found that the casino's request for relief in the form of preventing the licensing process could not be granted since the process was already complete, so the claim was moot. The court next considered the issue of standing due to an exception to the mootness doctrine, which permits the court to resolve an otherwise moot issue if it involves a substantial public interest. The criteria for invoking the public interest exception to the mootness doctrine are as follows: the public nature of the question, the desirability of the authoritative determination for the purpose of guiding public officers, and the likelihood of the question will recur. Because the act was intended to provide economic benefit to the citizens of Illinois and the casino seeks to collaterally attack the board's actions under the act, the issue of the casino standing to bring the collateral challenge is a question of a public nature. The court ultimately held the casino did not have standing, although Illinois courts generally allow disappointed bidders to sue the government entity that deprived them of a fair bidding process. The casino raised the issue of statutory noncompliance on the part of the city, which did not conduct a bidding process. The city chose not to certify the casino's application to the board, and it was well within the city's discretion to choose which application to certify. Therefore, the casino did not have any vested right to a certain process. Finally, whatever right Potawatomi Casino may have had in such proceedings no longer existed when Potawatomi Casino filed its action 2 years after the certification process ended. As such, Potawatomi Casino lacked a legal cognizable interest in the casino licensing process when it filed the suit issue. Thus, the appellate court's judgment was reversed and the circuit court's judgment was affirmed. Trying to talk as fast as I can.
Megan Mack, everybody. Question 2.3, 3.2. Whoa! A condominium owner, Elphelba, sues the City of Oz and her homeowners association, claiming that an ordinance restricting short-term rentals violates the takings clause of the Fifth Amendment. The ordinance allows HOAs to prohibit short-term rentals within their buildings and requests that the city enforce this restriction with its army of flying monkeys. Elphelba argues that she purchased the condo with the intent to use it for short-term rentals and improved her condo for that purpose. However, the HOA declaration prohibited short-term rentals at the time of Elphelba's purchase. Is Elphelba likely to succeed on her takings claim? Is the answer A, yes, because she had been renting the condo on a short-term basis for years before the restriction was enforced? Is the answer B, yes, because the restriction caused her significant financial losses? Is the answer C, no, because she never had a property interest in short-term rentals under the HOA declaration? Or is the answer D, no, because the takings clause claims cannot be brought against municipalities? For the answer, it's Greg Jones.
How many said A? B, C, D. The C's have it. No, because she never had a property interest in short-term rentals under the HOA declaration. This case involved a condominium unit in the city of Chicago. The condo owner brought an action against the city and the homeowners association in which he alleged the application to his condominium unit of the city ordinance that regulated home sharing by, in part, restricting short-term rentals violated the takings clause of the Fifth Amendment and was an inverse condemnation under the Illinois Constitution. The owner sought a declaration of the city, and the association had a duty to allow him to lease the unit on a weekly, monthly, or annual basis on home sharing websites. The ordinance at issue provided that it is getting loud up there. Does anyone else wish they were upstairs? The ordinance at issue provides that homeowners associations may determine that no short-term rental are permitted to operate within the building and ask the city to place it on a prohibited buildings list, meaning that no units in the building may be registered with the city as a short-term rental. If a condo owner rents out a prohibited unit, he may be subject to a fine of up to $5,000 per day if the violation continues. The plaintiff bought his condo in 2024 with the alleged purpose of using it as a short-term rental and, in fact, did rent it out on a nightly, monthly, and yearly basis until his HOA added the building to the prohibited buildings list in 2016. He then stopped renting it out on a short-term basis after the HOA threatened him with fines, and he claims that not being able to rent the condo had cost him over $40,000 from 2019 to 2022, and that his unit's value decreased by over $130,000. The takings clause claim is based on recognized regulatory takings theory in which, subject to certain exceptions, a regulation which denies all economically beneficial and productive use of land will require compensation from the government under the takings clause. For the takings claim to be successful, a plaintiff must have been authorized to rent the unit out on a short-term basis at the time he bought it. Although his original and amended complaints contained language from the HOA declaration he signed when he bought the condo, suggesting that he was authorized to rent the unit on a short-term basis, he misrepresented that language by omitting a portion which made it clear that short-term rentals in this building were prohibited on the date that he bought the unit. Even though he did, in fact, rent his condo on a short-term basis in violation of the HOA bylaws, he never had a property interest in the short-term rental. So, the takings claim and inverse condemnation claim both failed. The court dismissed these claims. Short-term rentals are great, but make sure you're allowed to by your HOA.
Greg Jones, everybody. Question 3. Round 3. A bicyclist was injured while riding on a village sidewalk after hitting a crack in the pavement, and he wants to file a negligence suit claiming that the village of Ancelia owed him a duty of care. There were no signs prohibiting bicycles on the sidewalk, and there was no bicycle lane on the busy street. Is he likely to succeed on his negligence claim? Is the answer A, no, because a crack in the pavement is not sufficient evidence that the sidewalk was in poor condition? Is the answer B, no, because the bicyclist was not an intended user of the sidewalk, even though he was permitted to use it? Or is the answer C, yes, because Ancelia Village has a duty to maintain its sidewalks for permitted users? The answer is B, no, because the cyclist was not an intended user of the sidewalk, even though he was permitted to use it. An Illinois appellate court ruled in favor of a village in a bike injury case in Johnson versus the Village of Palatine. In June 2020, a cyclist was riding his bicycle on a sidewalk adjacent to a high-traffic street. While riding his bike, the cyclist struck an uneven section of the sidewalk and was injured. He sued the village, claiming the village was negligent and owed him a duty of care to maintain or repair the sidewalk. The village asserted 3 defenses against the lawsuit. First, under the Tort Immunity Act, the village did not owe the cyclist a duty of care because the sidewalk was intended only for pedestrian use, while bicyclists were only permitted users. Second, the village also did not owe the cyclist a duty of care because the alleged defect in the sidewalk was open and obvious. Third, the village had discretionary immunity under the Tort Immunity Act regarding its allocation of funding to the proactive sidewalk replacement program. In response, the cyclist argued he was an intended user of the sidewalk because the high-traffic street did not have bike lanes, leaving him no other choice but to use the sidewalk. He also claimed he was an intended user because the village had ordinances regulating bicycle use on sidewalks in some areas. Finally, the cyclist claimed that since he was a citizen of the village, it was intended that he would use the sidewalk, so the village owed him a general duty of care. The trial court ruled in favor of the village, and the appellate court upheld the ruling on appeal. The appellate court first determined that there was no merit to the cyclist's claim that he was an intended user of the sidewalk. The court noted that the sidewalk was not designed for cyclist use, nor were there pavement markings or other indicators that the sidewalk was intended for bicycle use. Further, the village's own ordinances define sidewalk as being intended for pedestrians, with no mention of cyclists. The court rejected the cyclist's argument, and he was an intended user because he was forced to use the sidewalk. The court also rejected the cyclist's claim that he was an intended user of the sidewalk as a resident of the village because the act only imposes a duty on municipalities for uses that are both intended and permitted. The court did not address the village's open and obvious argument since it disposed of the case based on its finding that the cyclist was an intended user of the sidewalk, and as a result, the village did not owe him a duty of care. So municipalities should carefully consider how ordinances, designs, and markings express the municipality's intended use of the right-of-way. Meanwhile, for cyclists that might not like the outcome of this case, keep an eye on House Bill 2454. It would amend the Tort Immunity Act in response to this line of cases. Under this proposed law, a person operating a bicycle is deemed to be an intended user of every roadway or portion of a roadway on which bicyclists are permitted to ride. Stay tuned. Ladies and gentlemen, that's it for the APA-CMS Bar Exam. Here are our winners. Our top three teams tied for second place. It's the Redbeards. And Team 105. I think. Rick, what is the answer here?
Number one? Who won?
Oh, and the number one team for the APA-CMS Bar Exam, the 10th annual, who's about to be presented with the Ansel Glink Cup, a shiny 50-foot trophy. For our listeners at home can't see it. Oh, I only wish you could see it. It's so enormous. It's so shiny. Rick, roll it out for our winners. SR Collective, where are you? There we go. The Ansel Glink Cup for the winners of the APA-CMS Bar Exam. Oh, so excited. Thank you, Megan. Thank you, Greg. Before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@anselglink.com. And as always, you can leave us a voicemail on the Quorum Forum hotline at 312-604-9178. And as always, you can visit us online at quorumforum.anselglink.com. Thank you, audience. Thank you, listeners at home. Thank you, professors. One Lake Brewery, Engineer Rick. Can I get a motion to adjourn?
So moved.
Second, all in favor. The ayes have it. We'll see you next time on Ansel Glink's Quorum Forum podcast. Bye.